All right, everybody, hello and welcome to today's webinar. My name is Emily Spranger. I'm an academic trainer in the Center for Teaching and Learning, and I am very excited to be able to have one of our JFK faculty members presenting today. And we had a great little conversation before this started on the pronunciation of his last name, so I'm going to do my very best. But we have Bob Diodolevy.
Yes. Yes. Emily gets the star.
Couple of housekeeping things real quick before we jump into today's presentation. We are recording the webinar, of course, and we do want you to ask questions in the Q&A. So Bob's mentioned, absolutely have your questions come in through the Q&A, and we will get to those as time permits or at the end of the presentation. And the chat is available to you to just have conversation. So if you want everyone to see what you're posting in the chat, make sure that you do put your use the drop-down option that selects everybody. Otherwise, the selection sometimes defaults just to host and panelists. So that's if you want everyone to see your comments, just know that. Last piece of information, we do have a scrolling subtitle available to you in the Zoom. So if you would like to see that, you can hover over the bottom of your Zoom section and see the CC option. Hover over that and then select show subtitle if you'd like to see the scrolling subtitles as this webinar proceeds forward. So without any further ado, any more comments and housekeeping items, I'm going to go ahead and kick it over to you, Bob, to get started.
Thank you, Emily. It's nice to be here, folks. Thank you very much also. I appreciate you. And so we're going to jump right in, as Emily mentioned. We're going to first of all get into my sharing of my screen so that you can see my PowerPoint. And any questions, you can type them. Emily will relay them. Or if you want to wait till the end, we're going to try to leave plenty of time if you have questions, okay? So let me share my screen with you. And if you want this PowerPoint, no big deal at all, because Emily will have it, I'm sure, and also
yes,
I will be happy to share it with you. So you can see our kind of little bit of a title there. I titled this Copyright, notice the little cutesy C in the circle, but we're going to talk about that because a lot of people don't know about that little C, what it means, at least anymore. It's copyright law in the COVID era. And Emily did a great job with my name because it is a difficult name. I don't advise anybody, trying it without a net, okay? But it is Dr. Diodolevy. Bob is fine. Most of my students call me Dr. D. In fact, I have a funny story about that. I was teaching accounting, my very first job at Andover College in Portland, Maine, back in the 90s. And I passed out some exams back to the students. One of the students looked at her grade and said, "Now I know why they call you Dr. D." So hopefully not all my students do like that, but let's get started here and with a brief introduction. This be me. I've been an academician for 31 years, full-time as a law professor, and for the most part also as an attorney, 37 years, going on 4 decades. Yes, I be old. I know some of you aren't even 40 years old, but I'm an attorney in Florida and Massachusetts. And I used to be a broadcaster. I was a news director, assistant news director, staff announcer, production director, and the like in Massachusetts at radio stations from 1977 to 1985. Here are some caveats, here are some bewares. We can't do it all today. This could be an entire course in law school. It could be, and very well is, an entire course in law school, as well as in paralegal and legal studies programs and the like. But there's my email. It's my name, R. Diodolevy, and basically, of course, it's at nu.edu. So I'll give you that at the very end too, folks. You can jot that down. And if you have any questions at all, of course, we're going to try to tackle them in this presentation. But if not, you have something later, something comes up, it's like going to the dentist and you're going, oh, I forgot to tell them about that tooth. So if you have any nagging teeth, I can't help you there. I'm not that kind of doctor, even though I play one here in copyright land, but I am a doctor and you can at least email me, okay? So let's get to it. Copyright law, copyright is what we call intellectual property. And what we mean by that is it's an area of law that grants rights that are intangible. Intangible, you know what in means, right? Not insane, right? So in means not touchable. And examples of your intangible rights, for example, are your US constitutional First Amendment rights, right? Your right to freedom of speech and religion and petition and assembly and press and those wonderful rights. Oh, by the way, go home and bet some money. I want to try to win you some money. Ask your significant other to name the First Amendment rights. And if they do, they get $1. And if they don't, then they have to give you a quarter. And they'll bite on that. And you will have a collection of quarters like you don't believe, okay? Petition, assembly, religion, right? Speech, press. So those rights are intangible. Notice also what copyright isn't. It's an intellectual property, property of the mind, tangible versus intangible. These are intangible, can't touch them like the First Amendment rights. This is not a patent. It's not a copy, a trademark rather. It's not a trade secret. Okay, so copyright has nothing to do with those. Those are also intangible rights, meaning again that they're on paper. You can't touch a copyright. It's floating out there in the atmosphere, okay, in the stratosphere. You can't touch these rights like your First Amendment rights. But the Constitution of the United States in Philadelphia could burn to the ground and you would still have these rights because it's not the piece of paper that's the right, it's the right that's the right. And they're not patent, trademark, trade secret, okay? Got that? Good. How does copyright differ then from like trademark or patent and the like? We have some cute little graphics. A trademark is a word, name, symbol, or device which is used in trade. It's a mark in trade. And boy, we cleverly in law, we attorneys call it a trademark. And it has to do with, as you know, with goods. It indicates the source of them. It distinguishes them from other goods. Trademarks are used to prevent others from using a very confusingly similar mark. Hey, let's start a burger place and use the golden arches. That would be good. Wrong. Let's start a network and use a peacock. That's NBC. Let's start a computer company and we'll sell Macs and we'll have a nice little biteable apple. No, because those are the McDonald's arches, the NBC peacock, and the Apple computer. So we try to mark our goods so that we can sell our goods, we can get them out, distributed them to the public and consumer at large, but clearly we want different markings for different goods. That has nothing to do with copyright. A patent, most of you know what that is. It's an invention and it grants this intangible right, property right to an inventor. It's issued by the US Patent and Trademark Office in Washington. 20 years from the date of the application. And so now we see that copyright has nothing to do with that. It has nothing to do with a trademark, nothing to do with a patent. Well, how does that differ, Bob, from trade secrets? A trade secret is information. Again, it's esoteric, it's not touchable, it's intangible, it's floating out there. It's a formula written down, a pattern compilation, a program, device, method, technique, especially in computer land. A lot of stuff, trade secrets, right? I bet Apple has hundreds of them. It derives independent economic value because it's not readily ascertainable by proper means. It is a secret. And so as a result, we whisper when we talk about them, right? Here's an example. What is that special sauce in the Big Mac? Is it some type of salad dressing? 2 all beef patties, special sauce, lettuce, cheese, pickles, onions on a sesame seed bun. What is that exactly? Well, it's McDonald's secret. And so it's a trade secret. It has nothing to do with copyright, nothing to do with patent, nothing to do with trademark. It's a trade secret. Okay, they're all independent. And we could have an entire course today, and I know we only have an hour, but we could talk probably 16 weeks worth or more in a law school, a business, or a paralegal setting about intellectual property. We're going to focus in on just one type of intellectual property, and that is the copyright. And that's what you're here for. So let's recreate a photo. Let's have some fun. Let's take a look at this photo, folks. This is a photo that I found. Isn't she pretty? It's a beautiful girl. And she's in a beautiful blue cover-up. And she has a nice little bird in her hand. And she's just at the beach and laying in a bikini. And she has a beautiful backdrop of a wall. Oh, well, not everything can be beautiful. So what we do is, we're the Kupakoi Beach Club. And we're in Norwood, Massachusetts. And we see this picture of this young lady in a magazine. Could be 20 years old, 10 years old, whatever, but we love it. So what we do, we get our young lady to pose just like she did. And remember our club motto, we steal, I mean, we service anybody that comes along, so posh, so private, so legal. And we just have a wonderful color brochure, and we have our phone number there and the like. Do you see anything wrong with what we've done? Is there a problem? Now, come on, it's different girl, different lady. It's a different backdrop, different bikini, different cover-up. Is there a problem? Take a look very carefully, just take a little bit of look at it and see if you see any problems with us doing this, taking this picture of this young lady. Did we do wrong? Sure did. This is unauthorized copying of copyrightable elements, even though the model was different. It's the same pose, same composition, the subject notes, that even the bench is the same, and the hand with the dove is the same, and the shirt, remember her cover up, draped in a similar manner. It's the same thing. Look, this is stealing. This is a violation of copyright law. We are going to get sued by the copyright holder of this picture because this person, these people took this model and a photo and they own it. And as a result, we have violated copyright law, okay? Our copyright laws actually stem, ladies and gentlemen, from the US Constitution. Can you believe that? Go home and make some more quarters, okay? I'm trying to get you rich here fast. Ask somebody, where do we get our original copyright laws? Oh, Congress passed them or some statute or something. No, it's actually in Article 1, Section 8, Clause 8 of the United States Constitution. Our founding fathers thought, via James Madison, that this type of legal protection was so important to our structure of our country and society that they placed it smack dab in Article 1 of the Constitution. And this is what it reads. It gives Congress, talk about that in a minute, the power to enact laws, hit that in a second, quote, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Ask somebody at home or maybe at work, where do we get our laws from? Right there, that's where they stem from. Interesting, huh? Copyright, what is it? And where do we get it? You just told us, Bob, it's from the Constitution. But there's more. We have to talk about a little bit in depth what we mean by copyright, that intangible, untouchable, intellectual property right. The first Congress implemented the copyright provision in the United States Constitution in 1790. And then the same year, they came up with the Copyright Act of 1790. This is a legislative act by Congress, an act for the encouragement of learning by securing the copies of maps, charts, and books to authors and proprietors of such copies. And it's modeled on the Statute of Anne. This was a copyright statute in the early 1700s. Can you believe it? So for centuries, people have been trying in England and the United States and other places to protect their copyright. Now, when we talk about stuff like this, did you notice what I said copyright? And I talked about the US Constitution, yeah, right, folks? And I also talked that it was a thing you're gonna get sued on. Copyright, because Congress regulates it and passes statutes, it is federal civil. So we have to distinguish here. Most of the time, like 99% of the time, we are not dealing with state issues like torts, civil wrongs. Have you been injured in an accident? Morgan & Morgan can help you. Personal injury has nothing to do with that. It is not a state-based matter. Marriage, divorce, child laws, wills and trusts and all things like that, child custody, no. And it is non-criminal, 99% of this, and for our discussion today, it is non-criminal in nature, okay? So for the most part, 99% of the time, it's federal civil. We're talking about lawsuits. The copyrighted material is what we are focusing on, and we are protecting the plaintiff here in our lawsuit, the copyright holder. Why is the plaintiff suing? Because somebody impinged on his or her rights, and we called it infringement, and it is an infringement suit. So are we getting the language? It's a federal thing in nature, protected by federal law, Civil lawsuits arise from this because somebody has copyrighted material. It's the copyright holder, and they're suing. So now they're a plaintiff suing the defendant in a civil matter, civil litigation, civil court, and it is based upon an infringement suit. Nothing criminal here. Okay, how are we doing so far? All right. What isn't copyright? I know it's not trademarks, it's not patents, it's not trade secrets. Well, we said that, right? Has nothing to do with inventions. Protect that with a patent. Has nothing to do with trademarks. That's a symbol of your reputation, business, goodwill. It has nothing to do with trade secrets like the McDonald's special sauce, right? It is not that stuff, okay? What it is not continued. Several things do not enjoy this protection. Titles, names, slogans, symbols, designs, lettering, coloring. That all probably has to do with those other areas of intellectual property. Improvisational speech. I'm giving an improvisational speech right now, sure, but my copyright on the information that I'm giving you still is there. But if I were to get up in a nightclub and start sputtering this stuff, well, it's not protected by copyright. Unrecorded performances, the same thing. I get up and did a little dance or something, and someone said, wow, what a great dance. I've got to do that someday. We've just invented the new dance, the Watusi. Yeah, I know. I've just jumped you back, with McFly's time machine about 50, 60 years back, but even more. I know, I'm old, I told you. Concepts, devices, systems, computer, patent, methods, calendars. Sounds like intellectual property. Look to other possible protections, like we talked about, trademark, patent, trade secret, trade name, but these things are not afforded copyright. So we're kind of getting away from what is copyright, things that don't constitute copyright. So what is it? Our current copyright law, the updated version is the Copyright Revision Act of 1976. It was effective in January of 78. That is the big bad boy in the room. That's the bull in the china shop, ladies and gentlemen. That's the thing that we look at when we're talking about our current copyright law. Now, copyright law can be amended. New laws can come down the pike by Congress. They have. We'll talk about them. But also the U.S. Supreme Court. Remember, the Congress is the legislative body. They make the laws. The executive, the president, governor in a state, enforces the law, if we take jurisprudence here aside a minute. And we have the U.S. Supreme Court, the ultimate arbiter or decider of the law. So we have indeed had cases come down the street where the Supreme Court has told us about copyright law too. But there it is, your Copyright Revision Act of 1976. That's really what we look at, present day stuff. Pretty old though, huh? So how does copyright work? Copyright legally protects, remember, it's intellectual property. It's an intangible right. We can't touch it, but we have these rights according to the US Constitution, according to the Supreme Court, and of course, that 1976 act that was implemented in 1978, the Copyright Act. It protects works that are original. Got to talk about that. It protects works of authorship that are fixed. Got to talk about that. And they have to be in a tangible form of expression. If you hear a little rumbling, I'm in Florida and we get every afternoon a storm. We just had a little rain. And if you hear a little blah, 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 it's not my stomach or anything. I had lunch. It's really out there. Welcome to Florida, hurricane land. Okay. So hopefully you won't lose me. Copyright law then protects, everybody together, original works of authorship. What's authorship? That are fixed. We'll look at that in a tangible form of expression. So let's examine, let's dissect, if you will, friends, each and every one of those and see what is an original work of authorship. What do you mean by fixed? Because it's got to be fixed according to the Supreme Court, and it has to be in a tangible, touchable form of expression. Okay, stop right there, Bob. You just said that copyright protection is intangible, and now you're saying it's tangible. No, I didn't say that. I'm saying your protection is based on an intangible piece of intellectual property. You can't touch the right, but you've got to have it fixed somewhere in a tangible form of expression in order to get the right. See that? So you have an intangible right, but it's got to be fixed somewhere for you to have this copyright protection. Okay? Let's talk about originality. A major requirement, again, that the work has to be original. The work has to be independently conceived by its creator. It's got to be yours. You didn't steal it. So this is an example. This is a real case. Assume a teacher in Orlando writes an article called Understanding Copyright Law. Another in Omaha, Nebraska just completed a very similar work, same name. Neither one knows of each other's efforts. Both have the copyright. So both can call that Understanding Copyright Law. Both can have stuff about copyright. Both can cite Dr. D. Both can talk about originality, fixation, all that good stuff of copyright, and they both have the protection. Both of their works are protected. We'll see what protection gives you, but under that form, you're okay. What's tangible? This is a key factor. When you express yourself in copyright land, you have to have a tangible form of expression. So your original work, your original music composition or book or internet article or whatever you did has to be in a tangible, touchable form of expression. In other words, is it perceivable by others in a tangible medium? Well, no, it's in my head, like Einstein has a formula. Well, it can't be in his head. You know, if he has a machine or if he has a device, he's got to go get a patent. He's got to have schematics and drawings, and or maybe the actual box that the machine contains this wonderful stuff that he's invented, okay? And it's the same thing with us. It has to be in a perceivable, tangible medium. Maybe it's a book. Maybe it's in print. Maybe it is a program on a computer, in a computer system. Maybe it's something like a dramatic performance that you've written or a musical composition. It has to be in a tangible form where others can perceive it, others can be aware of it, others can see your expression, okay? So we have this intangible right. If you meet these criteria, you're going to get your copyright protection. We'll see what that means. See, so others can't infringe on it. And if they do, you bring an infringement lawsuit because you're the copyright holder and it's a civil matter. So you go to civil court trying to get all these terms right together. All right. Fixed. What does that mean? So now we have our original work. Let's say it's Harry Potter book, and it's in a tangible medium. It's in book form, manuscript form, screenplay form, whatever it is. It's on our hard drive. And now we have it, it's expressed. Is it fixed? Fixed means sufficiently permanent or stable to be perceived, reproduced, or otherwise communicated for a period of more than a transitory duration. A work consists of sound, images, or both. As being transmitted is fixed. So let's say now you're in this seminar here, this conference proceeding that we're having, this session with me, Dr. Diaghilevi, Bob here. Well, as a result, the university is putting this on. They have the copyright. And I have my copyright to my PowerPoint. We have things that are original expressions fixed in a tangible medium. And as a result, we have copyright protection. You now can't steal my, or take my, or borrow my. I like borrow better. That's a nice legal word. Legally or illegally, that is. You can't borrow this now and say it's your own. Put your name on it. And you can't take this presentation and say it's yours. Okay? Copyright protection. All right? So how are we doing so far? We've got all the bases. We know what copyright isn't. We know what it is. So what's protectable? What are the rights here? And how can we protect them? And what is protectable? Literary works, including software, anything you write. Musical works, I kind of hinted to that. Dramatic works, pantomimes. You didn't think of that, did you? You remember Marcel Marceau and Shields and Yarnell, for those of you that are old enough to remember that duo in the 70s. Choreographic works, dance. Maybe Paula Abdul came up with something back in the 70s, a choreographic work. Pictorial, graphic, sculptural works, motion pictures, of course, audiovisual works, sound recordings, architectural works, maybe drawings, schematics, and all you've put down on paper. These are all protected by copyright. So these are the things that we could do, we could work on, we could author, we could write or create, and we are the copyright holders. We're the creators. What's not protected? So let's look at the negative again. Ideas, concepts, discoveries. Go to patent law. Go patent the invention. Go get that thing set. Titles, names, short phrases, slogans. Do it our way. What the heck does that mean? That doesn't mean anything, copyright. Or have a good time. These are selling like hotcakes. Well, unless they're hotcakes, I mean, I don't know why we say that anyway, but those aren't protected. Works that are not what we just talked about, fixed, tangible expressions like an improvised speech or a dance, something you do off the top of the head. And in fact, something maybe, it was karaoke night. So you decided to go down there and do something and people loved it. And they're going to steal all your dance moves that you busted and the way you did it. And they're going to make a record, make fortune. Well, you should have done the copyright stuff to protect it. Works consisting entirely of information that's available and contains no originality. So something out there where the copyright has expired, or something where you start your book, the sun is up in the sky. Oh, I've got copyright protection. Everybody knows that. It's common knowledge. It's common information. Just because you tell us doesn't mean it's anything special. Anything written by the US government. That's why you get those tax returns and the government says, hey, reproduce them, give them to your friends, put them up on the internet, H&R Block, make copies and dole them out to people. The US government waives their rights. So if the person who came up with this, the copyright holder, the one who wrote this or penned this or authored this thing says, there's no copyright on this, do whatever you want with it, then you can. Those are the things that aren't protected. So what rights do we have as a copyright owner? What do we control? We have the right, obviously, big duh, to make copies of the works. We can distribute them. We have Harry Potter book, and not that I've never read any of them, but she can sell them. She can give them away. You can perform the work, and this is where you have something like maybe a book or a play or screenplay, whatever, and then it becomes a film. It becomes The Sound of Music, or it becomes a James Bond film or whatever. We can display the work on television. We can do it in the theater. We can put it on the internet. We have the right to make copies, distribute them, perform, display, and we can make what's called derivative works. Those are modifications, adaptations, new ideas. Star Wars 39, Yoda goes to the nursing home. I mean, something like that, okay? So we can do as much as we want with it as long as it's ours, okay? I told you, I promised you I would get to the little c because that was in my title, right? You know this, you put the little c in the circle and you get copyright protection galore. This is archaic as of 1989. This is no more, doesn't do a thing for you. In March '89, we joined something called the Berne Convention for the Protection of Literary and Artistic Works. It's a multinational treaty. It provides copyright protection, and it makes this symbol obsolete. Now, I still use it. You still use it. It's a cutesy little thing. I put it in my title. You don't need it, okay? Go home and make more quarters, right? You need the C in the circle. Copyright, 1997, Bill Kane. Oh, yeah, sure you do. No, give me another quarter. I'm telling you, put your kid through college this way. So by joining the Berne Convention, we recognize France, they recognize us. This isn't everybody. This is just the members of this convention. Iran, Iraq, okay? They don't recognize any of our laws, okay? They weren't a part of this. But there's something, a little bit of tidbit, no extra charge here, that you can use and just wow your friends and impress your boss. Copyright registration exists. It's not mandatory, but it's a good thing if you want to sue. If you're ever going to sue, you should go to the copyright, US Copyright Office and file for registration. It's a very important step if you're ever going to sue, because that way, timely registration allows you to collect monetary damages, and that's what it's all about, right? Damages and fees for the attorney, because this is civil law. If you don't think your copyright's going to be violated, if you're really not worried about it, if you're not going to make millions, somebody, like you're writing a book like Harry Potter or James Bond, I suggest you do this. But you can look at the US Copyright Office. So don't forget, remember, or if you don't want to remember, you don't have to do registration. It's pretty good to do if you're worried. You don't ever have to do the little c in the circle. Let's talk about your protection life. The length of a copyright as of 1978, it has a term of life of the author plus 70 years. If it's a joint work, it's 70 years after the last surviving author. For works made for hire And under pseudonames or any anonymous names, it's 95 years from publication or 120 years from creation, whichever is shorter. But just remember the magic 70 years, okay? It's 70 years after the death. It's copyright for life, okay? So you have a good, nice time to protect yourself under these rights. There are limitations of copyright. We're going to talk about a couple, especially for teachers, educators, academicians. There's something called fair use, teachers mainly, allows limited copying of copyrighted works for educational research purposes and for purposes of criticism, news reporting, teaching, anything like that. Fair use for scholarship, research, educational value. It's not an infringement of copyright. Now, Bob is not saying go get a Harry Potter book and photocopy it and distribute it to your class and say that's fair use. You are going to be sued because the Supreme Court in the Acuff case, Roy Acuff, some of you country folks, country fans know who he is, ACUFF. There's a very famous case, the Acuff case, where they come down with a 4-point checklist of what fair use is. And a huge factor is how does it impinge or impede on the economic value? By you taking that book and giving it to everybody, let's say it's Harry Potter, you are taking food off her table, out of her mouth, and money out of her bank account. You're not supposed to make copies of books and distribute it. As part of our course, we're going to give you this Harry Potter book, which I just photocopied 648 pages of it. No, because you teach that and your colleagues teach that, and you're at a big university and thousands and thousands and thousands of those copies. And who knows if other universities do this? Think of the money if she charges $30 a book, and there are tens of thousands, hundreds of thousands of these out there illegally. That's not fair to her. Okay, so can't do that. But under limited purposes, we can use fair use to teach and to write articles and the like. We'll get more into that. Is the internet copyrightable? Yep. Don't take stuff off the internet. Everything, assume, on the World Wide Web is copyrighted. Documents are easy to reproduce and distribute. That doesn't change a thing. Hey, I'll take Bob's a nice PowerPoint here that he sent me. I'll put my name on it. You're violating copyright, even though that's easy peasy way of doing it instead of doing your own. Digital content is still content. It's copyrightable. It's copyrighted. Copywriting is very important. Copying or reproducing is also important because it's illegal, possibly, very much so. When in doubt, get permission. Can I use this in my course? Can I do this? Can I do that? Check fair use, check to see, okay? This is hopefully educating you, if you're not really familiar with copyright law. This is going to make you a genius to your family and friends, but also, more importantly, to your boss. If you teach at an institution like NU, go to your boss and go, you know, I've been thinking about copyright. Maybe we should have that Bob fella come, and you know, he's worth millions, so he'll probably take a few thousand for to have a presentation, or you can do it. Notification of copyright status, again, it's not required. You don't have to have the little C in the circle. But remember that web-based materials are copyrightable, just like the print, the audio visual out there. Large portions of documents, images, web pages, you can't do that. There are guidelines we'll get to. Small portions by teachers we're going to talk about, yeah. Many web pages grant permission to educators. If you ever watch on TV like Nova, they'll say, educators, you can get this video free and show it to your class by writing us, or if you would like to record this and show it to your class, no problem. Great. They're giving you the opportunity to do that. If in doubt, shoot an email, request permission, okay? Do that. And usually on the website or in the book, there's a way to contact the person who wrote it. Let's talk about something called the Teach Act, friends. This is something, besides fair use, we talked about you can use things in a limited manner, and I'll give you some websites that'll explain that, because again, can't do it all in an hour. But this was signed by President G.W. Bush, November 2nd, 2002. And so it's 20 years old almost. This is called the Technology, Education, and Copyright Harmonization. Isn't that cutesy of Congress? TEACH. It offers many, many improvements over previous regulations. Remember, we were talking about that 1976 Act, sections 110 and 112 of the US Copyright Act. It is a great boon. It's a fantastic thing for we distance education, folks. I've been teaching online since about 1997, 98. And so this really helps by giving us not only in the non-digital world in the live class, but now we can use things digitally. We can use things online. Fantastic. Here are the requirements. In order to use copyrighted materials in distance ed to qualify for the TEACH Act, the following have to be met. And you don't have to memorize these. You can look at the PowerPoint, look at the video. It's going to be put up. You can consult articles I've written. Just Google my name, copyright. You'll find them. I don't steal them. And cite me. And also you can see these in other websites. I'll give you a couple in a minute. The institution must be accredited, nonprofit, educational. For the TEACH Act to work and protect you and give you these protections, the institution has to be accredited, not fly by night. Nonprofit, it can't be a for-profit television station, or it's got to be an educational institution. It has to be used as part of mediated instructional activities. You just don't give this out to everybody. Limited to a specific number of students, here's the key, enrolled in the class. And the use has to be live or asynchronous. I'll tell you how to protect yourself, folks. Here's the free legal advice. Have it with a course you're doing that's only available to qualified students who are users with a user name and password, and you're protected. Okay, so make sure it's in your course, username and password. It's not open to the general public. Only students in the accredited nonprofit educational institution have access to this who are enrolled in the class. That'll protect you. The use must not include transmission of textbook materials, materials typically purchased or acquired by students, or works developed specifically for online. So if I come up with a book, you just don't download it and give it to your students. Okay, ask permission, and you can't use the whole thing. Maybe you can select chapters or whatever. We'll see. Unfortunately, friends, it's beyond this lecture today. There are things out there like websites and the like, and there are handouts and all that will tell you what percentage you can use, 10% of a book and 20% of music or whatever. We don't have the time, but you'll find them. I'll point them to you, okay? The institution must have developed and publicized its copyright policies. And I kid you not, if you ever want me to talk to your institution or to a group of fellow teachers or educators, dean, academician, whatever, I'd be happy to do it. But we have to make sure that we have copyright policies. Go check with your dean, your boss, if it's your workplace, wherever it's not educational, wherever it is, see if you have copyright policies in place. At my institution where I teach full-time, Florida Gulf Coast University in Fort Myers, I was on the committee that revamped our copyright policies. Who owns what? Okay, the institution must implement technological measures. In other words, username, password, they've got all kind of firewalls, they've got their protections and all. And if they don't do that, they might get sued. You might get sued. See if your institution does that. Talk to your webmistress or your webmaster about that. Make your dean aware of these things. Maybe you guys should have a seminar or maybe some meeting or something or presentation. It doesn't have to be me, but someone like me who maybe has delved into this stuff, okay? Now, the COVID issues we promised we'd get to. How will the pandemic affect copyright law? During COVID-19, the Copyright Office, the US Copyright Office in Washington and the Library of Congress buildings closed to the public. These have changed now, things are opening up more, but the Copyright Office has been for the past couple of years open just for searching, registering works with the registration process, learning about topics and the like, but still services are limited. So when you go to the US Copyright Office, just be aware of that. If you're going by Washington, you say, wow, you know, what a great tour. It sounds like a tour Gomer Pyle would go on. Let's go see the US Copyright Office, golly, you know, not the most exciting thing in the world, but if you take a look at those things. Is anything different? Copyright law does not contain anything different regarding for COVID, for use in exigent or hot or really circumstances like COVID-19 and the pandemic. Fair use exception is not changed due to COVID-19. There's no clear-cut legality, legal authority as to if it's going to apply differently now or in the future. Stay tuned. I also do seminars and online courses and live courses on the First Amendment. And oh boy, some things have changed, as you know, especially when we were heavy and hot into COVID-19 with the pandemic. Boy, you can't have church. I don't know if we can have synagogue. I don't know if you can meet in this meeting. And you saw things in states, and I could tell you about cases. So here's Bob's tips. Civil law, mainly. You can get in trouble with the Digital Millennium Copyright Act signed by President Clinton. Sorry, we're out of time. You can look it up. But it's mainly civil, federal law. Review your intellectual property policy. Review that with your institution. Maybe they posted it online. Read your contract, friends. You have a written contract. Are there copyright policies in there? Well, my contract's a page long, it's 2 pages long. Yes, but do you have maybe a faculty handbook, what is called incorporated by reference? Is there incorporation by reference? And what that means, friends, is that your faculty handbook, it's like someone took a staple gun and stapled it to your contract. Everything that's in that 5,383 and a half pages applies to your contract. Who owns your copyrights? Who owns your stuff? Who owns the works? When you put up a course, do you own it? Is it half owned, half by you, half by them, equally owned by you and your institution? Does the institution solely own it? Make sure you know these things because it's your legal rights. Have copyright policies posted in your classroom, live and online. You remember how you go in the copy, the Xerox machine, the faculty room, whatever you'd like to call it, the office area, and you see all these posters for the Americans with Disabilities Act and all that stuff. Well, I bet also next to them, besides sexual harassment and racial discrimination, all those posters, I bet you there's a copyright poster. Before you use this machine, here are the federal copyright laws. Maybe you should have them in your course. These two are great websites. Again, when you visit this again, when you watch this, maybe on YouTube, when it's put up, Baylor is excellent, and the American Law Association, Library Association, excuse me, the ALA, the American Library Association. This is terrific stuff from Baylor and the ALA about copyright. It'll explain more the Teach Act, your copyright rights, and the like. And just have to Google Baylor University Copyright or ALA Teach Act. And they have some excellent stuff beyond the parameters of what we're doing here. To get me, again, I promised I would tell you this. There I am. It's my email, rd.levy@nu.edu. If you have any questions, we have maybe about another 10, 15 minutes here we can get to. You can share with me and I'll try to answer them. I'm not practicing here online as a lawyer or anything. I'm trying to just give you some legal advice from my vast expertise of it. But what I'm trying to say also is if I can help you in any way, point you in the right direction, we can do it now or we can do it later. Either way, I'm going to send you a bill. I mean, come on, I'm a lawyer. No, I'm teasing. So just anything you'd like, we can maybe tackle some stuff in there. Thank you, before I forget anything, because I know we're going to run out of time here in about 10, 15 minutes, but thank you very much, folks. I appreciate you. I thank you so much for being here. I've enjoyed it. If you need anything, from me, absolutely, please just, shoot me an email and the like. Okay, and I know we got some questions, so.
We do. We have some that popped up in. Oh, can you see me? I'm sorry, I didn't mean to freeze there for a second. I apologize about that.
No problem.
Okay, couple of questions here. This one popped up when you had that photo of the woman in the bikini. So what about people who make art from pictures in magazines, like collage or paintings based off of those pictures, right? So if someone's doing an impression of a photo, what about that? Is that a copyright violation?
It depends. If the copyright is expired, and I can tell you for a fact, the Mona Lisa, that's pretty well gone. I don't know if that ever had copyright protection. So if you want to draw, Emily, the Mona Lisa, you want to do your impression of it, and you want to put Madonna's face on it, or Britney Spears' face, or whatever you want, your own face, that's fine. But yeah, you got to be careful, because if I put something up, I have copyright protection. If now all of a sudden you're going to draw it, and if I'm the copyright owner, I'm very flattered. But when you start producing it, and remember that Acuff case that the Supreme Court handed down decades ago, if it impinges on, affects the economic value, my market value of it, and all of a sudden now you're selling it for $10 a pop based upon my creation, my idea, then I've got major problems and you're going to be sued for copyright infringement.
Yeah, yeah, and this person just popped in the chat about this topic that we're talking about right now, just
Yep.
how they see it on social media quite frequently, and just had wondered, you know, if it's
Yeah.
copyright
Yeah.
violation. But I think you're right. As soon as the money piece comes into it, right?
And they get wind of it. That's it's very much, Emily, of McDonald's.
Mhm.
I don't know if you've heard, if you're old enough to know this, or maybe heard it in history, but McDonald's lawyers went tediously through every business they could find in America named McDonald's that was a restaurant. And
Ah,
they sued and sued and sued and sued until, because they got the big, litigation
okay.
machine. You cannot find, very difficult to find a burger place called McDonald's.
Okay.
They won't even find a turkey burger place called McDonald's, because McDonald's haven't caught up to them, maybe, if you found one. But yeah, they wanted the McDonald's burgers. They wanted it nationwide. And so what they did was they said, hey, that's, our trademark. That's our name. We have our secret sauces and special stuff, and nobody else can even touch the name. And so that's what's going to happen. The big machine, if it's something like Apple computer, and you have even a little Apple on something,
Mhm.
and it has to do with computer related. Now, if you want to have, like, let's say, a Genesis tree service, and you're a Christian and it's Bible based from Genesis, and it's Adam and Eve type thing with the apple, and that's your logo, they don't have a problem with that. But when you start getting into and delving into computer land, oh, they're going to come after you. So that's the thing. Just be very careful who you're attacking, the monetary nature of it and the like. And even if there's no monetary values, still technically it could be a violation of copyright, because copyright has nothing to do with money. So if I come up to Emily and I hit her hard on the back and she goes, hey, I know something about law, that's battery. Not only is that a crime, but that's also a tort. You could be arrested for that and sued for that. Forget about it. A tort has occurred.
Mm.
A crime has occurred, even though she said, forget about it. Still, she could sue me tomorrow on it. Still, a policeman saw me, could take me in right now. Doesn't have to do with anything of what the person thinks or how much money is involved or anything like that. It's all what the law has to think of.
And I'm glad you're talking about that money piece as well too, because there's a few other questions in the
Sure.
chat, but this one is kind of tied to this first one that we've been talking about. And Vincent popped in the chat. Would that money be connected to the actual piece of work or to the ad revenue that is generated?
Everything. Everything, Vincent, everything. So if you are making money, let's say that, I wrote a Harry Potter book, again, to use that, I keep hitting that example. So I'm the author, and you take my work and you make a derivative work, all the same characters, whatever, all that monetary gain, I am suing, and I'm going to get my fair share. A very interesting lawsuit was, as most of you know, MC Hammer did a song, Can't Touch That, right? Can't touch that. Well, he took that literally. I think it was Rick James. He literally took that and stole the music, put his lyrics on it, and he basically just flipped his nose and said, I don't care. It's going to be such a big hit. Sue me. And he got sued, and he made $50 million and had to pay, I think it was Rick James, $10 million. But he said, what a terrible illegality. I get to keep 40 million. He just didn't care. He just flipped his nose at the law and said, let's do it. Hey, if you think that you're going to make a lot of money, and I guess technically I'm not saying to do that, but you're going to have to pay the piper. You might have to pay all that money, some of that money, you're going to get sued. You're going to have to get dragged through court, pay legal fees. Is it worth it? Just go to the copyright holder and say, I would like to make a derivative work from this, or maybe make a new work from this. Could I do that, please? And if they give you permission, then you're going to avoid all the lawsuits. Just don't steal.
Absolutely. It's a great food for thought. Don't steal, just in general.
10 commandments or something. Who would have thought,
So we've got Cheryl popped a question in here, and I see this quite frequently. But so if we use Google Photos on our PowerPoint and reference, so you're referencing your photos, is it okay to use the photos in an assignment?
Yeah, because that is going to fall under teach most likely, but definitely fair use. You're referencing the photos. They're out there. Google put them out there. Probably no problems.
Okay.
Yeah.
Another thing here. At the college where I work, this is from Melissa. At the college where I work, students are uploading our worksheets to Course Hero and sharing with the world.
Oh, good. Love that.
Do we have any protections with that?
I love that. Yes, I meant to mention that, Melissa. I'm so glad you mentioned it. When you have your protections in place, especially for the Teach Act and the like, and you tell your students in a live class, don't steal. If others put it up, if others steal, that's their problem, not yours. You are not to be the police person of the universe. So there's a student online, this has happened before, where they're in the course, and one of their buddies says, hey, what's that, man? That looks great. Well, my teacher gave it to me. It's fair use, it's Teach, I'm on my course. Would you email that to me? Student's in trouble. The student is the one who's going to get sued by the copyright holder because you did everything you could do. You're covered. Don't worry about it. And the guy that stole it is going to get in trouble as well. Not you, not your institution.
Interesting. And that is good to know. And I'm so glad you did touch on the Teach Act piece. I think it's very important.
Yeah, those websites do have a lot more. You can look at, like I said, the ALA, they've got a great summary of it. And they have bits and pieces as what you can use, what you can't. Again, it's beyond our hour, but I want to just give kind of an overview, a smattering, as we lawyers do many times, not what the law is, but where to find it. And so when you go to a lawyer, Emily, and they go, let me get back to you in 2 days. That means they have no clue what it is, but they'll go find it, become an expert overnight, and sound like a genius.
They're going to go research. Yes.
Yeah. And so that's what I want you to do. That's your homework assignment, everybody. Go research, sound like a genius, get a big bank again with the quarters, and you fill them up as you keep keep testing people and the like. You know?
Oh my goodness. That's great. Well, first of all, I'd like to thank our attendees for participating, asking some questions. Melissa laughed. LOL, lawyers and librarians have a lot in common that way. I thought that was a funny joke, Dr.
But let me tell you something. Let me tell you something, Emily. It was so cold in Florida last night. So cold. They found an attorney with his hands in his own pockets.
Stop it. That is hilarious. Dr. D, thank you so much for coming and presenting, and our attendees, thank you so much for asking questions. We really appreciate it. And until the next time, I hope you all have a great rest of your day and take care.
Thank you.
Bye-bye.
Bye.